What is Section 1192.2? Driving while intoxicated, per se. Driving under the influence is a serious offense in New York, but not all DWI charges are based on erratic driving or slurred speech. Under Vehicle and Traffic Law Section 1192.2, a person can be charged solely based on their blood alcohol content, regardless of how they were driving. This legal standard, known as per se DWI, can make charges easier to prosecute but also introduces unique challenges in court. Understanding the law, per se DWI under VTL Section 1192.2 applies when a driver operates a vehicle with a BAC of 0.08% or higher, as confirmed by a chemical test. For commercial drivers, the legal limit is even lower at 0.04%. What sets this law apart is that no observable signs of impairment are needed, just the BAC result. The law requires that tests be conducted using approved methods such as breath, blood, or urine tests, typically within 2 hours of the alleged incident. Prosecutors rely heavily on chemical test results to secure convictions. However, these tests must be accurate, conducted properly, and performed with devices that are regularly calibrated. Officers also need to follow strict protocols and be certified to administer the tests. Any deviation can be grounds for challenging the admissibility of the results. Answering the question, what is Section 1192.2? Section 1192.2 defines a specific type of DWI offense in New York, one that is based entirely on a driver's BAC rather than their ability to operate a vehicle. It applies to individuals with a BAC of 0.08% or more while driving. This charge is different from others under New York law that require proof of visible impairment or erratic behavior. This standard streamlines the legal process but also makes chemical evidence the centerpiece of the case. That means even if a driver seems sober, they can still be charged and convicted under Section 1192.2 if their BAC was over the legal limit. The law focuses on objectivity, but it also leaves room for defense strategies that question the reliability of test results and law enforcement procedures. The process and penalties. The process begins with a chemical test, typically a breathalyzer. If administered correctly and on time, this result becomes the primary piece of evidence. To be admissible, the test must be conducted by a trained officer using calibrated equipment, and the driver must be observed for 15 minutes beforehand to avoid contamination from food or mouthwash. The prosecution must also maintain a clean chain of custody and proper documentation for the results to hold up in court. For a first-time conviction under Section 1192.2, penalties can include fines from $500 to $1,000, a minimum 6-month license suspension, and up to 1 year in jail. The installation of an ignition interlock device, IID, is also mandatory. Repeat offenders face higher fines, longer license revocation periods, and felony charges with prison time up to 7 years. Aggravated offenses carry even steeper consequences. A BAC of 0.18% or higher qualifies as aggravated DWI, increasing fines and jail time. If a child under 16 is in the car during the incident, the offense becomes a felony under Leandra's law, with possible prison time of up to 25 years if the child is injured or killed. Why legal representation matters? Because per se DWI cases revolve around test results. A lawyer can play a critical role in challenging the evidence. Maintenance records, procedural lapses, and physiological conditions affecting BAC levels can all become central to the defense. An attorney may identify improper calibration, mishandling of samples, or even lack of probable cause for the traffic stop. The law firm can also argue that the BAC level rose after driving had ceased or that the 2-hour testing window wasn't met. These arguments may introduce reasonable doubt, which can significantly impact the outcome of the case. When you're facing a per se DWI charge, having the right legal team is essential. The law offices of Jason Bassett, PC, brings deep experience to each case, carefully analyzing every detail to protect your rights and fight for the best outcome. Contact the law offices of Jason Bassett, PC at 631-259-6060 or visit us at 320 Carleton Avenue number 4200, Central Islip, New York, 11722 to discuss your case and begin building a strong defense.